Hey, TikTok friends, Joe Concepcion, the Heartland Defender here. I've been winding down the operation for the year over the past week and looking forward to taking a week off to celebrate the new year and spend time with family. But before I could do that, I had one last day of court this morning and ended the year with a bang with an exciting win both for my client and his family and the Eighth Amendment. So as we all know, according to the Eighth Amendment, you have a right to bail out whenever you've been arrested for charges. This is not absolute. There are two situations in which the state can continue to hold you. One is if they move for a pretrial detention and you've been charged with certain serious offenses, and there's a hearing on that, and we'll talk about that in another video. For our purposes, what we're going to talk about today is Arthur hearings. So you have an Eighth Amendment right to bail, and you also have that same right under the Florida Constitution, Article 14, and basically you have to be given some sort of bail to be able to get out of jail. Now, as I'm often fond of complaining about, there's always a catch. There's always somewhere where the government seems to put its thumb on the scales and limit our constitutional rights. In this case, my client was charged with a kidnapping offense. That is a felony punishable by life, and under the state constitution, the rules of procedure, if you are charged with a felony that is punishable by life or is a capital offense, then they can hold you without bond if the state can prove that the proof of guilt is evident or the presumption is great. According to case law, this is a very, very stringent standard. In other words, when we go in for that hearing, the state needs to be prepared to prove their case to a standard that's even higher than that of a jury's deliberations. In other words, you have to prove a case beyond a reasonable doubt at trial to get someone held with no bail, no bond on an Arthur hearing. It needs to be proven beyond a reasonable doubt. This is a very high standard. And today, the facts in the law carried the day. The judge found that the proof of guilt was not evident or the presumption great, and that my client had a right to bail. Bail was set on that kidnapping charge along with the rest of his charges, and now he can go home to celebrate the New Year's with his family and continue to work on the case and defend his case from the outside, which is always a better place to be. Happy New Year, everyone.